Zimbabwe's mining sector has long operated under the Mines and Minerals Act, Chapter 2105, a statute first enacted in 1961. This colonial-era law has been criticized for its outdated provisions, weak environmental safeguards, and the lack of clarity regarding land rights and indigenous participation. Over the years, demands for reform have grown louder, particularly following land reform, increased artisanal mining, and foreign investor interest in Zimbabwe's rich mineral reserves. The Mines and Minerals Bill 2025 represents a comprehensive attempt to modernize the country's mining laws. This article provides a legal yet accessible analysis of the bill, outlining key changes and assessing whether these reforms are progressive or problematic. One of the core reforms introduced by the bill is institutional. It renames and reorganizes key mining bodies for better governance. The Mining Commissioner, a holdover from colonial administration, is replaced by the Provincial Mining Director, PMD, who will oversee local licensing and compliance matters, see Section 31. This is both a symbolic and practical shift, reflecting a new administrative structure aligned with decentralization. Meanwhile, the Mining Affairs Board, Section 715, is reconstituted to include diverse representation: farmers, small-scale miners, accountants, professional bodies, and experts from civil society. Its mandate includes hearing appeals, overseeing licenses, and shaping mining policy. The inclusion of representatives from civil society and professional bodies on the Mining Affairs Board is a commendable move towards transparency and inclusive governance. However, given that all appointments are made by the minister, there remains a legitimate concern about whether these appointees will act independently and without political influence, especially in decisions involving licensing, appeals, and strategic mining oversight. A groundbreaking development is the introduction of the Mining Cadastral Register, Section 1722. This digital system will record all mining rights and titles, making them publicly accessible and enforceable. This change seeks to tackle corruption and land invasions. Crucially, the bill requires the registration of beneficial ownership, disclosing who ultimately controls the claim. This provision is very important because in the past, influential people secretly owned mining rights using other people's names. It is imperative to note that now the law will require the real owner to be disclosed so that the public knows who truly benefits. It aligns with global anti-money laundering standards and promotes legal certainty. The bill simplifies the landscape of mining titles. It reduces them to three main forms, which are claims, mining leases, and special grants. This is a welcome departure from the confusion caused by overlapping categories in the old law. Moreover, the bill abolished extralateral rights and secondary reef claims, which previously created legal ambiguity and overlapping claims. Notably, the new exclusive prospecting license system, Sections 3135, introduces clarity by tying a license to a defined geographical area, with a cap of 40 hectares. This limits speculative prospecting while prioritizing serious operators. In addition, it is worth noting that staking agents now replace approved prospectors, Sections 23-29. This change professionalizes claim marking and helps reduce fraudulent pegging. Section 215 provides that all miners must contribute to an environmental rehabilitation fund. This fund will be used to restore land damaged by mining after operations cease. It addresses the legacy of environmental neglect, particularly from small-scale and illegal operations. Additionally, community engagement is strengthened through corporate social responsibility requirements. The bill also introduces obligations to respect landholders' rights, especially for resettled farmers who now hold land via 99-year leases or offer letters, Sections 3640. This is a positive move that harmonizes mining law with Zimbabwe's land tenure system. The bill introduces a new concept, which is strategic minerals, Section 6. These are minerals deemed vital to Zimbabwe's economy, security, or development. Lithium and rare earth elements are likely candidates. Any party wishing to mine such minerals must sign a prior agreement with the state, and may be required to invest a minimum of $1 million, form a joint venture, or offer state equity participation. This ensures national benefit from strategic resources. Instead of relying on the overburdened criminal justice system, the bill introduces civil penalties for regulatory breaches, First Schedule. These include fines for illegal pegging, cutting timber, or mining on protected land. PMDs are empowered to issue civil penalty orders. If ignored, these can be recovered in court like debts. This pragmatic shift allows swift enforcement while still preserving the right to appeal to the Secretary or Administrative Court, Section 38. One major improvement is clarity around land use. Under Section 39, farmers can reserve up to 100 hectares of uncultivated land for future farming, protecting it from prospecting. Miners must negotiate access to water designated as restricted public water, Section 4. These provisions balance economic development with agricultural and human rights. The bill wisely removes excessive technical detail from the primary legislation and places it in subsidiary regulations. This makes the law more adaptable and accessible. For example, pegging methods and inspection requirements will now be set by ministerial regulations. Section 313 repeals the existing act, but provides for the seamless transition of existing rights. Titles issued under the current act will remain valid until they are integrated into the mining cadastre. This ensures stability and reduces legal uncertainty. The Mines and Minerals Bill, 2025 marks a significant step forward for Zimbabwe's mining sector. It modernizes the legal framework, enhances transparency, and aligns the mining regime with the Constitution, international best practices, and socio-economic needs. While many reforms are commendable, such as the mining cadastre, environmental fund, and recognition of new land tenure, care must be taken to prevent excessive ministerial discretion, particularly around strategic minerals. With vigilant implementation, the bill could unlock the country's vast mineral potential while upholding environmental justice, indigenous rights, and the rule of law.